So I want to talk to you today about the difference between two key decisions in the VA claims process, a BVA decision and a VA ratings decision. Well, a lot of you guys and gals that have been at this for a long time know the difference. Not everybody does. So the question's begged, well, I guess that's not really a proper use of that's my appeal brain, my brief writing brain going there. I don't need to talk about the meaning of begging a question. The point is that a lot of you are probably wondering why I'm talking about something so basic, and it's because there are a lot of veterans out there watching this that don't have the knowledge that you have. So let's bring them up to speed. There are two key decisions in the VA claims process that affect your ability to continue your claim and get the maximum amount of past due benefits that you can get. And those two decisions are the VA ratings decision and the BVA decision. And they're very, very different decisions, and I see a lot of veterans confusing them. And I know this because, again, on the law firm side, when I ask somebody to send me in their BVA decision that they want to appeal, a lot of times, 90% of the time, I'm getting a VA ratings decision back. And that's a significant difference because there's different appeal timelines, and the impact of missing an appeal on one or the other can be fatal to your case. So let's talk about the difference. We have to start with a basic understanding of what this VA claims process is all about. There's two components. There's a claim side and there's an appeal side. Okay, so the claim is where you ask the VA for the benefit, and they spend, 1 month, 1 year, 1 decade, 1 century, however long they take, deciding whether or not they're going to grant or deny your claim. Once that claim is denied, at that point you shift into kind of an appeal mindset. And so there's two stages to the appeals level. And the first stage is the BVA appeal, the Board of Veterans Appeals. And you're taking that VA ratings decision to a board that's staffed by what they're calling themselves now veterans law judges, but they're attorneys that have been at this for a while, or I guess now there's a whole bunch of new ones coming in. They've gotten some massive new hiring thing going on at the board there. But in any event, the board judges are looking at these VA ratings decisions and making a decision yay or nay. Most times they're not saying yay or nay. They're sending it back to the regional offices to fix something using the remand authority. So that's the second piece of it, is the appeals. But once you get done with that board appeal, that's an administrative appeal. So it's the executive branch of the government, the BVA, executive branch, right? They deny it. Most times, in most other legal structures, you then have a right of judicial review. All right, so you would be able to take that administrative executive branch action, which is a denial, and take it to court to have the judiciary branch review it to see if the executive was acting within or without the law. Now, there's no such judicial review for veterans. None, never has been. We're not allowed to take our cases into district court. The only court appeal we get is to the Court of Appeals for Veterans Claims. And I'm not going to go into all the constitutional law history, but it is not. It is a court set up under the congressional authority, not judicial authority within the Constitution. So it's essentially, I don't want to say it's a congressional court because that's not entirely right. It's a court, and these are actual honest-to-goodness judges on this court, but it's a little bit different in that you're not getting a jury trial. They're not looking at facts. They're looking at whether or not the VA on the administrative side follow the law, right? The only time that you get into an honest-to-goodness judiciary branch court is if the Court of Appeals for Veterans Claims denies your appeal. You can go to the Fed Circuit, but the review capacity of the Fed Circuit is so small, it's so narrow, that you have to have a pretty significant issue to get the Federal Circuit to issue a decision on your case other than a denial. So the point to all that is claim and appeal. Those are the two pieces of the process. Within that appeal process, you've got a board and an administrative appeal, and you've got the court, which is a quasi-judicial review. Why do I mention that? The VA ratings decision takes you from that claims process into the appeals process, but it's only into the board appeal. The board decision takes you from that board appeal, that administrative appeal, into the court appeal process. And the timelines are hugely different. Okay, so when you get a VA ratings decision, you have 1 year from the date of the notice of action letter delivering that decision to file your notice of disagreement. That's not traditionally your appeal. Your appeal is then followed. If you follow that step and you properly file a nod, and they'll be posting the show note to talk to you about how to file a nod properly, what needs to be in there, the key ingredients. I'll even walk you through a VA ratings decision so that you can see how it works. Once you file that nod, then the VA gets another crack at looking at it. You might ask for a DRO to review it, and the DRO can grant it through a ratings decision or issue a statement of case, an SOC. If they issue that statement of case, that's basically their administrative denial again. And then you have 60 days to file a VA Form 9. If you miss that deadline, you haven't filed your appeal to the board, and the only way to start it over is to reopen your claim. All right? Let's say you do file your VA Form 9 on time and you get all the way through to the board decision. You then, let's say the board denies your appeal. At that point, you have 120 days to appeal to the Veterans Court, or the Court of Appeals for Veterans Claims. That's a pretty hard and fast deadline. Now, there is some opportunity for what's called equitable relief, which is saying there are certain times, or equitable tolling, I think is a technical legal term we want to use. But there is some consideration for the fact that there will be occasions where you miss deadlines. But missing the 120-day appeal deadline into the Veterans Court, it's really hard to get one of those exceptions. I just read a case here recently within the last 2 weeks where somebody filed on the 121st day and their appeal was dismissed because the court didn't have jurisdiction because it was outside the timeline, and this particular person did not provide any equitable basis for why they were a day late other than they miscalculated the date. So hard and fast rule is probably the best way to go with that, unless you're in a coma or unless you are, completely out of commission. Even being out of country is probably not good enough. You've really got to be out of commission medically, mentally, physically, some way, some absolute inability. I looked at another case where a vet, the things that happened to this poor vet were incredible. He lost a family member, he lost a parent, I believe. He was suffering from a pretty severe uptick in his own mental health condition related to PTSD, and he missed by a couple of weeks, and the court still came back and said, no, that's not good enough. The point to all that is not to slam the court. The law is the law. The court's applying the law. It doesn't matter. I'm not saying anything negative about the court. What I'm saying is you need to know the difference between a VA ratings decision and a BVA decision, because if you miss that deadline off the BVA decision, you're sunk. You're sunk. And it's important because something really critical happens at the BVA. You go through, you have your BVA hearing. If you do it by video, you do it by travel board, or if you skip the hearing and submit things in writing for them to consider. Once the board issues that decision, the record on whatever claims they denied is closed. It's done. You cannot get more into the record on that claim without going all the way back and reopening your claim, in which case you've lost your original effective date. So the only way to reopen that claim, reopen that appeal, is through the Veterans Court. You've got to go there, show an error in the board decision on some level, and 75 to 80% of them have an error in them. Whether or not it's a reversible or a remandable error is another question, but 3/4 to 80% of them have errors in them. And you can go to the Veterans Court. If they remand it back, then it opens things back up and you keep your original effective date in most cases. And so it's really important that if you have a claim that you think was done wrong, decided wrongly, didn't have the right evidence, something was done wrong with the evidence, it's important to know to appeal to the Veterans Court and to do so on time. If you get a board decision in the mail and you think it's a VA ratings decision, and you think, oh wait, I've got a whole year, you wait a year and file that appeal, you're sunk, you're toast, you got to start all over again, right? So it's important to know the difference between the two. And sometimes most of you folks that are listening to this are saying, Chris, it's fairly obvious the difference between the two, and I'm here to tell you it's not all the time. So let's talk about a couple of them. So the board decision is probably the most recognizable. I'm going to show you a couple copies of them. These will be screenshots. If you're watching this as a recorded version, just scroll down, you'll see screenshots of these documents. If you're watching it live, I don't have the ability to pull up a different screen right now, so what I'm going to do is I'm just going to hold them up to the screen. There's some black lines on this. I've crossed out people's names so that you can't see their names or any of their socials or anything like that. But I want to show you what a board decision looks like. All right, so whoop, that's the second page. That's the hard part about doing things backwards sometimes. So this is a BVA decision, and you know it's a BVA decision because it says right up at the top here, it says Board of Veterans Appeals, right? You can recognize it. It says in the appeal, it's going to have your name right here, your docket number. That's your board docket number, okay? And it's very different from this number over here, which is your claim number. So there's two types of claim numbers. There's a C claim and a CSS. Basically depends on what era you first filed your claim. CSS is basically your social security number. C claims are not, so they're related to a different numbering system. But the docket number down here that you see, where's the docket number? Right here. Good Lord, I can't do things backwards. The docket number is a little different. I shouldn't have, crossed it out completely, because what I want you to see in that is that the very first two numbers of your docket number in a board decision are the year, should be the year that your VA-9 was certified or filed. So that's, if you call up the board right now, let's say you filed your VA-9, you want to find out if you've got a hearing coming up, ask them what your docket number is. If they don't have a docket number, they haven't gotten your VA Form 9. If they have a docket number, ask them for it, and those first two numbers should match the last two numbers of the year you filed your VA Form 9. So you filed your VA Form 9 in September of 2014, you should have 14-whatever as your docket number. If you don't, there's something wrong, and that could be that they just, most times it's that they use the date that they got it certified, not the actual date of the VA-9. That's big because that can, push your wait time for a hearing back a year. So if that's the reason, if they've given you a date that's a year, 2 years, 3 years after your VA-9, ask them to fix that to your actual VA-9 so that you'll get in line in the queue. You get bumped up in the queue and you get your hearing earlier because they work in docket number order. All right, so that's the first reason. Another reason is that the docketed appeal is not the one you think it is. And this is a very common reason. So a lot of vets, they file their VA Form 9 on, let's say, a fibromyalgia claim in 2013. Then 2015, they file a VA Form 9 on their carpal tunnel / traumatic brain injury appeal. They call up to find out what their docket number is on the fibro claim, and they get a 2015 date. That should be a huge signal that either they just crossed up the dates and got them wrong, or that there was no appeal certified to the board on that original claim. So it's something you need to get to the bottom of pretty quick. It's one of the big reasons that folks sit in this hamster wheel so long, is that they don't know. We're not told what our docket number is most times. You got to call up and find out what it is. But that's what a board decision looks like. That's the very front page. You can recognize it. It says it's on appeal from the regional office. Make sure it matches the right regional office, and it'll list the issues. And down here on the bottom of the page, it usually has your representation, whether it's, just the veteran, whether it's a VSO, or whether it's, in this particular case, it was the Legion. So that's how you recognize it. If you're not entirely sure after that, the last page of it will always have a signature of the name of a particular veterans law judge. In this case, it's S.L. Kennedy. That's how you know who the veterans law judge is. If it doesn't have that signature on it, it's probably not a board decision or not a valid board decision. But that said, if you get a board decision that doesn't have a signature, appeal the darn thing anyway, because, well, we'll just leave it there. So, easy to spot a board decision, right? Let's take a look at VA ratings decisions, which are a little bit different. So there's actually more versions of the VA ratings decision than we have pieces of paper in this office. And I think we've got, boxes of it in the back there. I don't know why that was relevant. I was really just kind of thinking on the fly of a metaphor, but it really didn't work. So in any event, there's a lot of different kinds of VA ratings decisions, and there's no rhyme or reason to how they look. So here's one that we got in March of 2016. All right, you look at it and it says, what to do if you disagree with our decision, and then it goes on about what is e-benefits, blah, 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 blah. I mean, buried in here is your appeal rights right there. I blacked out the portion that talks about what the relief was not. It was a denial. But that's one way that they look, all right? It's got this Department of Veterans Affairs, no address, the little eagle up in the top. It's got claims numbers over here. It's got the veteran's address and the date. Sometimes you'll see handwritten dates. Sometimes there's no date. Sometimes it's stamped on there with an old date stamper. That's one kind. So take a look at that structure right there, all right? Here's another kind right here. Totally different look, right? That's another kind of VA ratings decision. Most commonly, you're going to see, well, I'm not going to say that. You'll see this a lot from the DROs. So if you get a DRO decision, it's going to look a lot of times like this. As you can see, it says Decision Review Officer. This is one of our cases. I blacked everything out again. But you can see it says on here, Department of Veterans Affairs, there's a regional office, and it says is a decision review officer decision. You see it on there. Back in the old days, they used to do it on blue paper. Every once in a while, you still see it showing up in a C-file as blue paper, not so much anymore. That's another kind. Here is a third kind of VA ratings decision, and this one that goes through and says, you know, we made a decision regarding your entitlement to VA benefits, and then it lists on a little chart the payment summary. There's patterns to when these different types come out, but just so you know, they're all a little different. I have never seen the VA go more than 6 months without some sort of adaptation or change. Sometimes one regional office uses one style, others use another style. It's mayhem, and so that's why I say this process is a clown car. But it's important to know the difference between those two documents. From the VA ratings decision, you've got 1 year to file your notice of disagreement. That notice of disagreement is the first step to appealing to the board. When you get a board decision, you have 120 days, not from the date you get it, not from the date you get it, not from the date on the cover letter of the board decision, from the date on the board decision itself, right? So let me show you that. That's important. Here's the board decision that I was showing you earlier right here. This is going to be your date stamp right here, okay? You get a cover letter with your board decision, and that cover letter often has on it another date, and it can be the same day, it can be the next day. I've seen it happen where they were issued 2, 3, 4 months after the date of the decision. If that's the case, you have a possible argument for missing the appeal deadline. If the actual letter was sent out to you more than 120 days later, it ain't a slam dunk case. You got a good argument, but the bottom line is this is the date that starts your 120 days, is the date that's stamped on your board decision, okay? So it's important to know that. It's important. I really honestly think it's important to get an attorney at the Court of Appeals for veterans claims off a denied board decision. There's some pretty significant statistics that show a pretty wide disparity in represented versus unrepresented veterans. Pro se veterans often lose their court cases. And that's not, I'm not saying that as a dig on the court. There's a reason that happens. And it's because the court is the first level of the process that's adversarial in a judicial sense, or a judiciary sense, I guess, as you will. Forgive my poor use of language there. When you get to the court, you are making legal arguments in a structured way. You're taking facts, you're taking the law, and you're applying the law to the facts to say that a certain outcome should have happened. And most veterans are not trained in how to do that. And judges, these are really, really experienced attorneys. Some of them have been judges at some level of the process. Some have been attorneys in this process. Some have been attorneys in other processes before. So they're really looking for these arguments. And one of the core tenets of a court is that they're not going to go hunting for your case. And that's either side. If the Secretary of the VA has an attorney at the Veterans Court and they don't make their case good, the court's not going to go out there and help them. Now, some judges have a leaning to the VA. Some judges have a leaning to veterans. Some judges have a leaning to the law. Some have a leaning to the facts. Every judge is different, right? So I'm not saying that, you know, they're going to always, if this other side doesn't make their argument, that it's always going to go your way. I'm not saying that at all. What I'm saying is when you get to the court, you have to make a structured legal argument that the judge is used to seeing, and it has to be in the words of the law. And a lot of pro se veterans aren't able to do this. There's some that are. I've seen some really, really awesome stuff come from pro se vets. But most of the time, that's not the case, and the court doesn't go hunting for issues, and so the VA's attorneys are able to smack them down pretty quick. So if you have to go to the Court of Appeals, I strongly, strongly recommend getting an attorney. Hop on the blog. There's a free book about how to choose an attorney. It's a free ebook. There's a paper version. The link will be in the show notes. You got to pay for the paper version, but that's only because the publisher is charging to ship it and all that sort of stuff. So in any event, get an attorney if you have to go to the court. You don't necessarily need one if you're just filing a notice of disagreement off a VA ratings decision. A notice of disagreement needs to be two things. It has to be an intent to appeal, notice of intent to appeal the VA ratings decision, and disagreement with the VA ratings decision. So, and you have to do it on this new form, 210958. Used to be you could just, take a piece of tissue paper or an index card and write, I disagree and want to appeal, and you are good to go. Now we need a form, 21-0958. There's a link on the show notes down below that talks to you about that form, about how to fill it out and get your NOD filed. But you don't need legal training to file a NOD. Most veterans with a little bit of education, kind of like the education we provide here on the Veterans Law Blog, hadit.com does a great job of putting that information out. Ben Krause on disabledveterans.org does a great job putting out information about how to appeal some of the voc rehab stuff. So there's resources out there. My good friend Matt Hill over at Hill and Ponton, they've got a great blog on their website that's meant to educate and teach about this area of the law. So hop on there. You can usually piece together a really solid appeal to the board without an attorney. But again, we're seeing statistics come out of the board that say that attorneys that are representing veterans achieve better results than veterans going pro se. It's marginal at this point in terms of, you know, VSO versus attorney. There's a big disparity, attorney versus pro se. So when in doubt, you might want to get some professional help, but don't be discouraged in your own board appeal just because you're not a lawyer. On the other hand, don't go to the court without an attorney. Just don't do it. There's no point in doing it. An attorney can do a better job. You don't have to pay attorney's fees at the Court of Appeals for Veterans Claims. If you hire an attorney and they win, that attorney can make the VA pay out of the VA's pocket under the Equal Access to Justice Act, not out of your pocket. Okay, so you would not have to pay the attorney directly. Don't let that discourage you. A lot of people out there say, oh, I can't afford an attorney at the Veterans Court. Nonsense. Doesn't cost you a dime. At most, you'll have to pay a $50 filing fee out of pocket, and that's only if you cannot show that you have a financial hardship to get that fee waived. In any event, I've babbled on enough about board decisions, VA ratings decisions. Hope it was helpful. If you have any question about whether you've gotten a board decision or whether you've gotten a ratings decision, you know, shoot me a support request and I'll take a look at it. Premium members, of course, are going to get that quicker response.